I'll just start recording. Morning, everyone. Today's session is on law for accounting. My name is Shazia Khan. The learning outcome we're going to do today is to understand company and insolvency law. So in the last session, we looked at understanding the elements of law that affect any sort of commercial practice. We looked at things like contract law with reference to how a contract is formed. We looked at the issue around the elements of a contract. We looked at terminating contract. We looked at some case law in regards to a valid contract and how and why a contract can be breached. We went on to look at the law of agency with looking at the principles of agency, the rights and duties of an agent. And we looked at the agent relationship and case law, and then we went on to look at the law of tort and looked at negligence, negligent misstatements, vicarious liability and remedies. And now we're going to move on to look at understanding learning outcome 2, which is to understand company and insolvency law. So the indicative content for today's session is quite a lot on there. So firstly, we look at the formation, financing and administration of companies, procedures for companies and limited partnership registration, including memorandum and articles of association, advantages and disadvantages of limited companies and limited liability partnerships compared to partnerships, sole traders and other structures, the veil of incorporation and when it can be lifted, requirements of Companies Act for statutory accounts, audit meetings, registers and general administration, exemptions for medium, small and micro enterprises, procedures for the issue of shares, including shares issued at a premium and preemption rights, capital maintenance, shares distribution of profits, share transfer requirements. We then look at directors, officers and shareholders, so appointment and removal of directors' powers, roles and duties, consequences of breach of duty. We will go on to look at the influence of shareholders on company through meetings and resolutions, shareholder statutory rights and member rights for limited liability partnerships, role of the company secretary in company and limited liability partnerships. And then we go on to finally insolvency, which we'll be looking at implications of fixed and floating charges over assets, company voluntary arrangements, admin orders, receiverships, compulsory and voluntary liquidation, means of termination of companies, priorities for distribution or liquidation, rights of creditors and employees, and bankruptcy and personal solvency. So firstly, we'll start with the key terminology to identify what is a company. And it's a legal entity which has a legal personality separate to those who own or run it on a day-to-day basis. So the company is a separate legal entity, separate from its shareholders and the part owners and its directors and its managers. So the diagram identifies on the side that they've got the veil of incorporation, lifting the veil, and the types of business organisations. So you've got incorporated, unincorporated, types of companies, private, public, promoters, and then down to registration, records, articles, alteration and legal effect. So the veil of incorporation, and when can it be lifted? Nationality. In times of war, it's illegal to trade with the enemy. It may be possible to lift the veil of incorporation so as to impute to a company the same nationality as its members. Why do you think it's important in regards to lifting the veil of incorporation?
To remain within the legal remit allowed by the company's, registering country.
Yeah,
it's like sanctions, meaning you can't.
Yeah. But is it in some aspects important to have this veil of incorporation?
I would say yes.
Yeah.
For many reasons, meaning tax is one.
For taxes.
Tax is one. Laws and regulations that are applicable to the company. Is another one.
But in times of war, obviously, it may be time where you have to lift the veil of incorporation, so that you are in line with the same nationality as its members. And the case in regards to this was the case of Daimler and Continental Tire and Rubber Company, 1966. And it identified the facts in this company that the defendant, a UK incorporated company, was owned by 5 individuals and a company incorporated in Germany. Only one individual was British and he held 1 share. In this, the courts held that the claimant need not discharge their debt to the defendant since effective control of the latter was in the enemy's hands, and hence to do so would be a trade with the enemy. Types of companies. So we have private and public. Private company versus public company. So we have the definition of a private company is registered as a public company. And for the definition of a private company, any company that is not a public company. The name of a public company, it ends with PLC or public limited company, and the name of a private limited company ends with limited, LTD or limited. The capital for a public company must not be less than the authorized minimum, currently 50,000, and in order to trade must have allotted shares at least that amount. And then the private limited company, there's no maximum requirements. Now, in regards to raising capital for the public companies, it may raise capital by advertising its securities, shares and debentures as available for public subscription. Private companies prohibited from offering its securities to the public. So start of trading for the public company must obtain trading certificate from registrar before commencing trading. For private, can begin from date of incorporation. And the directors for a public company, the minimum is 2, and for a private, the minimum is 1. For the public company, the secretary must be 1 and must be qualified. And for a private company, they need not have 1. For the accounts must be audited. And for a private company, need not lay accounts before general meeting, must file within 9 months. The audit must file for a public company within 6 months, and audit not required if turnover below 6.5 in a private company. For the AGM, it must be held each year, and the private company need not hold an AGM. The resolutions for the public company can't pass written resolutions, but for a private company, they can pass written resolutions. Consequences of incorporation. So there are a number of consequences of being a separate legal entity. I mean, they've given us a list there, which is, firstly, a company is liable for its own debt. If a company feels the liability of the shareholder is limited to any amount still unpaid on the share capital. The second one is a company enters into contracts in its own name and can sue and can be sued in its own name. And thirdly, a company owns its own property. Fourthly, a company has perpetual succession irrespective of the fate of shareholders. Fifthly, the management of the company is separated from its ownership. And then sixthly, a company is subject to the requirements of the Companies Act 2006. Now, when we look at the Companies Act, why do you think it's so important that companies are registered with the Companies Act 2006 and that they meet the requirements of that act?
That's the meaning in order for a company to be legally
That's the law,
established. I
isn't
think,
it?
yeah, exactly.
That's
So
the
it has to be.
legislation that needs
Yep.
to be put in place in case anything happens in
Exactly.
regard to, you know, the incorporation or registering of the company and things like that. That is the act that deals with everything. And there's different sections within that act that would deal with how a company is registered, how they have incorporation, how someone can be sued. And these are good things to have in place because you can follow the law to do things like that. Because sometimes in some countries, and I will give you some examples where countries don't have law in places and do things in line with what they feel.
Yep.
And
like established framework, basically.
Yeah,
You know,
they
for the
have their
protection.
own.
Yeah.
They have their own framework of
Yep.
how they think a company should run, and they don't follow the law. And in that instance, you know, the company suffers. Okay, and it doesn't follow the law, and things don't go right for that company. So where a company suffers an injury, it is the company itself that must take the appropriate remedial action. This is known as the rule in Foss and Harbottle. And in this, the rule was that it is a general principle of company law that an individual shareholder cannot sue for wrongs done to a company or complain of an international irregularities. The principle is commonly known as the rule in Foss and the case of Foss and Harbottle. So what is company law? Company law is essentially the law that governs the creation of registered companies. It is very easy to identify core company law today, as it is almost containing 1,300 sections and 16 schedules, as I mentioned earlier, of the Companies Act 2006, regulations made pursuant to that act, and cases clarifying the application of the statutory rules and principles. So there are rules and principles that we must follow to adhere to any sort of regulations that are set out in the Companies Act. Certain aspects of core company law, such as remedies available for breach of directors' duties, remain case stated. Law distinct from statute law, and many cases interpreted of past companies law act. So we, as if you're a judge, you will rely on past precedent. Okay, what does past precedent mean?
Previous examples of cases and scenarios.
Yeah, and why would we? Was that Hanish?
Yeah.
Hanish, why would we rely on past precedent? Does it?
It's a template
Yeah,
where previous judges'
yeah.
decisions have been.
So does it help us support? Does it help the judges support their decision for the next case then?
Yes, if it's of a similar nature.
Yeah. If the cases are similar, okay, we rely on them cases. Now, historically, the law may have been really different. So, we could rely on parts of, the law, or maybe there's rules and policies that have been put through that case that we rely on principles. So it might be that we may rely on things from that case, even though there are similarities, but the law may be a little bit old to rely on. So then we rely on the case, but take in consideration the new laws. So, past precedent is there to help through common law, to help support judges and come up with the right decision. I mean, in some cases, I will identify to you, the judges sometimes don't make the right decisions. And I don't know if it's just me teaching, what I teach law for the last 15, 16 years. But I think I have this perception in my head sometimes when I've dealt with cases and gone to court, judges are not always fair. I mean, I don't know how you lot think about that. Do you think when judges are making decisions, they're always following the law?
Yeah. So, in corporate or tax situation, what we call it, sometimes it's a technical kind of decisions, right? Based on technical grounds rather than matter of principle or, kind of common sense sometimes.
Yeah. When we look at things like, things like criminal law, just an example for you, if there's a case that's gone through for criminal law, a case of murder that can be reduced to manslaughter, self-defense and things like that, sometimes judges, I will tell you, I dealt with a case for an insurance claim. So it was an insurance case where the young boy had drove the car without insurance. Okay, so he should have really got a suspended sentence. Yeah. The judge gave him a custodial sentence of 12 months. Okay. And then now we look at the fairness of it. So then there was another case at the same day that the judge had, it was a paedophile. And he looked at images of children and performed, sexual activity with the child. And he was given a 12 months custodial sentence. Sorry, a 12 months suspended sentence. So do you think the law's fair when we look at the crime in this country? Because he was a paedophile and he'd committed a crime that had been given 12 months suspended sentence, and the one that had no car insurance was given a 12 months custodial sentence. Do you think that's fair?
I think it again, it's relative, right? Meaning one is, I think, risk involved there, right? I mean, on the face of it doesn't look fair, right? Meaning I
don't think it's fair. To be honest, when I represented him, it's car insurance is a big difference to sexual abuse. Do you know, with a child? So
of course,
sometimes, when you look at cases from that perspective, you think sometimes the law is not as fair as it should be. I mean, some of you may disagree with me, I have worked in practice for 10 years. I do know how, sometimes it is unfair. And I do know why in some cases it is fair as well, but I just think sometimes, when we look at the law in this country, it's sometimes, there are discrepancies.
Yep.
I think that's in everything though, isn't it? Maybe.
It's everything. Meaning
Yeah.
even today, meaning I know we'll probably digress. I look at the interest rate market right now,
Yeah.
right? So the Federal Bank of England keeps increasing interest rate. That interest rate instrument is not supposed to be used in the way the current economics are working. Again, it's a 100-year-old instrument, maybe even older.
Yeah.
So yes, it's dated
It is.
and
It
detached
is.
from the current reality.
Yeah. It's quite debatable, isn't it? It's quite yeah. So the next one is company law includes parts of security regulation and insolvency law. So companies law would include insolvency law and securities law. The latter is part of a larger body of law known as capital markets law or financial services law to the extent that they apply to companies. In the last 20, 30 years, each of these areas has become a highly developed and voluminous legal subject in its own right. Corporate governance. Why is governance so important within an organization?
Or proper running the business, proper running the company. Yeah.
The running of the company is so important that the company is run well and the company is run within the law and is lawful. When we look at making decisions and what any sort of legalities you need to follow. Corporate governance is not a legal term, rather it is a label or heading under which the questions how, by whom, and to what end corporate decisions are or should be taken are analysed and reflected upon. Core company law and corporate governance overlap to the extent that a large part of the core company law is a body of laws and rules and principles establishing how and by whom corporate decisions may lawfully be made or legally required to be made. Various sources of company law. So you've got Companies Act 2006, Insolvency Act 1986, Company Director Disqualification Act 1986, Financial Services and Markets Act 2000, the Criminal Justice Act 1993, Companies Act 1985 looks at company investigations, Companies Audit Investigation and Community Enterprise Act 2004, company investigations and company interests and companies. Why do you think we need so much legislation in regard to company law or any sort of things that govern the law around companies?
Because it's important.
Why is it important?
Why it is important?
Yeah. Why do we need why do we need law in place to look at investigations?
Yeah, meaning again, depending on the situation, safeguarding, right? Process, what is legal, what is illegal, what is allowed, what's not allowed. I think that you need the law.
Do you think? And I go back again to go. Do you think companies rigorously follow the law?
Not always.
Not always. No, you're right. Not always. They don't always rigorously follow the law in regards to, maybe, how they treat the staff and things like that. They don't always follow the law completely because within company law, you've got the employer's rights as well, things like that. And they don't always follow the law clearly when we go to look at the issue in regards to discrimination. I think it's later on. You will see that. 2.1. Analyze the requirements of company law for formation, financing, and administration. So when it's got 2.1 at the top, that will help you towards doing your assignments, so you'll know where to find your information.
Right.
Okay. So although there are different types of companies, such as public limited companies and private companies limited by guarantee, by far most and popular business entity in the UK is a private company limited by shares. So it's a limited liability company, LLC, and a private limited company, PLC. Why form a company? Although other business structures exist.
Can I just ask a question? I thought PLC was a publicly limited company and LLC was
limited liability company.
Yeah. So I think terminologies are mixed up here, right?
Yeah.
And Americans obviously call LLC. LLC means the private company.
Yeah, public limited company, yeah. Yeah, that's right. You're right in that one. Yeah. Why a company is formed. So although other business structures exist, such as carrying on business as a sole trader or forming a partnership, the primary reason you should consider forming a company is that the liabilities of the owners and directors of the company are distinct from those of the company. Your personal exposure to creditors of business and litigation against the business is therefore limited. Do you think it's really important in every company to have a director?
Yep.
Why?
Because they're agents of the shareholder running the company. Shareholders are not running the company, directors are. So you need
Directors
a
are
driver on the driving seat. Let's put it
yes.
that way.
So the directors are the main ones, aren't they?
Yep.
Advantages of forming a company. So forming a company may bring other advantages too. You might find it easier to raise finance. You can formalize ownership and voting arrangements within those who are involved in the business. A further legal administrative benefit of forming a company is that the legal and regulatory framework governing the operation of the business is comprehensively dealt with the most part in one place, which is the Companies Act 2006. And that's the main framework that deals with a lot of the stuff. How to form a company. A company is formed by filing series of documents with the Registrar of Companies at Companies House in accordance with the main legislation governing company law, the Companies Act. Company is officially brought into existence when a certificate of incorporation for the company is issued. Is the Companies House quite helpful in this? Is it a good thing to have the Companies House there to set up?
They are pretty good.
Yeah, I think it's excellent actually.
Very,
I
very
think
good.
it's very good when it was set up to help companies, establish themselves, but also, give them support as well. Form INO1, which requires certain basic company information be provided, such as a company name, who the initial directors and company secretary will be, and who the shareholders of the company will be, and the memorandum of association and articles of association. Things to consider. So the company name. The name of a private company must end with the word limited. There's no two English companies can be the same. A company name and cannot contain any sensitive or offensive words. When choosing a name for the company, it's also important to remember that if the name of the company is too similar to that of another trademark, you may be in breach of trademark. A company can voluntarily change its name by passing a special resolution under Section 78 or by any other means provided in the articles. The Secretary of State requires a company to change its name in the following circumstances. So firstly, the reason is the name is the same as or like or an existing registered company, and the period is 12 months. The name gives so misleading an indication of the nature of the company's activities as to it's likely to cause harm to the public. So there's no time limit. Misleading information or undertaking where given and applying for a name that required approval, and that's 5 years. When we look at something that may be harm to the public, what kind of name could be a harm to the public?
Meaning you might be selling completely GMO products and calling it natural, whatever, kind of, so.
Yeah. Or something that, may affect an individual, maybe a word that, anything to do. An example would be if you put into a name terrorism or something. Into your company name, or anything like that could affect the individual and the public. Shareholders and share capital. Number one of the advantages of forming a company is that it allows you to further formalize the ownership structure of your business. This is done through shareholdings. Number two is a company must have at least one shareholder, who must hold at least one share of at least 1p. Subject to this minimum requirement, there are no restrictions on the number of shareholders, shares, or denomination of shares. Number three, it would also be worth considering at this stage the possibility of having more than one class of share. Having different classes of share allows different shareholders to have different rights in respect of, for example, dividends, voting, and ability to transfer shares. The ability to create a share and ownership structure with different classes of shares, especially useful if you are looking to attract private investment, as investors may require different rights to attach to their shares. Directors, as we said, they are one of the main people in regards to a company. One of the most important components of any company is the board of directors, which is comprised of those persons who carry out the day-to-day management of the company. When forming company, you will need to consider who to appoint as the initial director of the company. I am a director for a company, and I always, try to help that company. I mean, I work voluntary for a company that deals with a charity that deals with women that suffer domestic violence. And I am one of the directors, and I am the chair of the company as well. And it's not, I mean, you don't have if you're voluntarily doing it, I don't think you have a bigger role. I think whilst you're working in the company, your role is a lot more bigger because it's day-to-day management of that company.
Yep. It's executive versus non-executive, right? Meaning obviously
Yeah.
as executive, you have responsibility running the company. Non-exec is more for governance and
I kind of
advisory.
we deal with a lot of the governance and stuff side of it. And deal with the day-to-day management of that company, but we don't have an input on the day-to-day basis. So, we meet up every 6 weeks to kind of discuss governance, things like that around the company, the organization, sorry. But it does, governance does play a role in like things like policy making and things like that. In doing so, the following considerations should be borne in mind. The minimum number of directors required to form a company is usually 2, although it's permissible to have a sole director provided such sole director is an individual and not corporate entity. B, there's a maximum permissible number of directors, although it could be inconvenient for a small company to have a large number of directors that have been involved in management decisions. A director who is an individual must be at least 16 years old. English law does not have nationality or residence requirement in respect of directors, and it's also advisable to have directors and officers insurance in order to protect directors from claims of wrongdoing that could be personally liable on. Secretary. When forming a company, do you think a secretary, her or his role is quite a big role within a company as well?
It is. Again, for private limited, it's somewhat limited, but publicly, of course, there is lots more.
Yeah, I think they do have a big role within a company. Personally, I think they do, are there to support the directors, but also have a big role within the day-to-day running of a company as well.
Yep.
When forming a company, you will also need to consider whether you like to appoint a secretary of the company. A UK company may have a secretary, but there's no longer a requirement for a private company to have one. The secretary may be, but does not have to be, one of the directors, and another individual or company may act as a secretary. One of the factors to consider when deciding whether to appoint a secretary is that English law imposes a significant number of duties on the secretary, including the maintenance of minute books and registers. Despite having these duties from the company's perspective, a secretary would be useful to appoint in order to ensure the company's administration requirements are met, and the company does not find itself in breach of Company Act. I mean, does anyone know of any organisations or anything that you've worked in regards where they have breached conditions of Companies Act?
Well, we are always careful in looking at what the articles allow us to do versus what we actually intending to do.
Yeah.
And at times we have obviously had to modify.
But do you think there are companies out there that breach the laws in regards to,
I'm sure there are. Yeah.
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 There are companies out there that are, not following the requirements and wouldn't want, and the thing is, mainly it's the thing on the expenses, isn't it? Paying for something. Companies don't want to do that.
Yep.
As part of, registered office, as part of a company formation process, you will also be required to state the intended registered address of the company. A UK company must have a registered office in England or Wales. This will be the address for the formal service of legal proceedings and other formal documents. It does not need to be the principal or indeed any place at which the company carries on business. As a practical matter, it is often convenient that the secretary should be based at either the registered office or the principal place of business. If you are unsure as to where the office should be, it should be noted that the company's registered office can be easily changed at any time by a board resolution or a form sent to Company's House.
Shaji, but we did say that you can't have a round robin resolutions for publicly limited. So if publicly limited company is changing address, it has to have a board meeting, is it?
Yeah.
Right. Okay.
Do you know, like, if you're registered with the company's house as a director, you know, this is the experience I've got when I've worked with this company, that they've put my personal address on there, and I think that's something. For me, I don't think it should be put on there, and that's my personal opinion. I don't know what anyone thinks.
Yeah.
It's because company's house register is available to everyone, isn't it? Really?
Yes, it is. Yeah.
And when it's got your personal address on,
Yeah.
it's something that I mean, that's my perception. I don't know how anyone else feels about it. I don't think it should have your personal home
I agree.
address on it.
I agree.
Well,
Absolutely. It puts you
because
to put at risk as well, by the way.
yeah, it's a risk, isn't it? Because it's open to everyone,
It's like
and that's
GDPR as well. There are other
yeah,
things.
and that's the issue around me having some sort of debates with the company and with the charity, that, you know, is it safe? Do you know what I mean? Because we've had instances where, because it's domestic violence, we've had
Yeah.
instances where family members have come to the organization, and what
Yeah.
if? So, you know, it's a safeguarding thing.
Yeah.
I
I
think
think there is
that's
a way. There is some procedure where you can mask it. I think there is. There is a way. I know. I was reading it.
okay.
Oh, yeah. I think there is something that you can have a dispensation from that, getting it publicly. Yeah.
Yeah, I just think because it's open to everyone, I don't think
Yeah.
it's safe.
It's not safe. I agree.
And again, we look at like confidentiality, GDPR, and
Yeah.
everything.
Yeah.
And this, because we've had instances where directors have been pursued by ex-service users. So, you
Yes.
know,
Yeah.
it's quite
I think it's a
scary, to be
creditor.
honest.
Yeah, creditor's protection is one thing, right?
Yeah,
Meaning, I understand that creditors would want to know where the directors are if
yeah,
if company fails to,
yeah,
kind of make whole for the debt. But again, you're right. On personal level, it's a risk to the directors.
yeah, it is.
Their
What do
name
you
is in
think
public.
about that,
Yeah,
Hanish?
it's
Do you,
That's the
was he on? To Irene? Anyone? What do you think about that? Oh, they're on. They're on. Okay, we'll carry on. Constitutional documents. So the two constitutional documents which companies are required by the Companies Act to have on incorporation are Memorandum of Association and Articles of Association. The Memorandum of Association, which must be in a standard form, simply states that the initial subscribers for the shares in the company wish to form a company under the Companies Act and have agreed to become members. And then the Articles of Association essentially is a contract between company and each shareholder and regulate the way in which a company is conducted. Do you think it's good to have these two forms of documents in place?
Yeah, I couldn't agree more. I think
Yeah, I
article,
think yeah, I think it's very
definitely.
good. Yeah, I think it's good to have these two documents in place because they help support an organization as well. So articles of association are often the statutory model articles, which are model articles prescribed by regulations made under the Companies Act and amended certain provisions. The unaltered model of articles is automatically adopted by the company in cases where a company does not submit any articles of association with Form 1N01. When deciding whether to rely on the model articles alone, consideration should be given to the wide range of uses of the articles of association and can be put to on how they can meet the needs of the company. As the document which governs the proceedings of the company, the articles of association can include provisions to cover all manner of subjects such as voting rights, dividend rights, termination of directorship, and the sales of shares. 2.2, analyze the role and responsibility of company directors, officers, and shareholders. So the Company Act 2006 imposes general duties on a director of a UK limited company. A company acts through two bodies of people, its shareholders and its board of directors. They're the main ones, aren't they?
Yep.
The board of directors are in charge of the management of the company's business. They make strategic and operational decisions of the company and are responsible for ensuring that company meets its statutory obligations. Your role as an individual director is to participate in board meetings to enable the board to reach their decisions and make sure the company's obligations are fulfilled. The directors are effectively the agents of the company appointed by the shareholders to manage its day-to-day affairs. The basic rule is that the directors should act together as a board, but typically the board may be also delegate certain powers to individual directors or to a committee of the board. You may also be a shareholder or an employee of the company, and if so, will have additional rights and duties going beyond those purely connected with your office as a director. General duties of a director, firstly, is to promote the success of the company, to exercise independent judgment, to exercise reasonable care, skill and diligence, to avoid conflicts of interest, not to accept benefits from third parties, to declare interest in proposed transaction or arrangement. Indirect responsibilities can be done by an accountant, registering for business tax, VAT, pay, pensions, filing an annual confirmation statement, filing annual account statement with Companies House, filing company tax and annual accounts of HMRC, and reporting company changes and registering for self-assessment. A company director can also be held personally liable for acts or omissions committed during the course of their appointment, including unlawful discrimination, endangering workers' pensions through chronic mismanagement, health and safety, environmental breaches, corporate manslaughter, and willfully ignoring the involvement of the others in fraud, bribery, or money laundering offences. So you could see that the company director has quite a big role, doesn't he? He or she. And things like that could become a criminal offence, couldn't they?
It is, and it's further extended by the securities law, like the industry I work in, asset management and banking, right? Meaning the securities law has a huge requirement on directors.
Yeah.
And goes to personal level liabilities.
Yeah, they could, like it said, they can be sent to prison and they can be disqualified for 15 years.
Yep.
So it's quite a big thing, you know, like if you're a solicitor or a barrister, and it's mainly a solicitor, and you're struck off for a large amount of time, and it's the same as a company director. You know, the severity of the offence will get you struck off.
Yep.
You know, fraud, bribery, whatever it is, money laundering, it's a serious offence, and you could go to prison for that. And I think it's a good thing, because not in a bad way. I think it's a good thing because Companies Act identifies that any sort of laws, that if you breach them, you will have to, you know, face the consequences. So, you know, directors need to know that.
Yep.
Duties of shareholders, and there are, sorry, I'll go back to it. There are lots of directors out there that do commit fraud, and you know, within a company, fraud, money laundering is a big thing. Yep.
Sometimes meaning infamous, you know, kind of case law. Well, it's not a case law, but tax, right?
Yeah.
Taxi companies are a famous front of criminal proceeds, basically.
Yeah. Duties of shareholders. So the shareholders of company are effectively the company's financial supporters. They provide finance to a company by purchasing shares in the company and thus become shareholders. So what rights do they have? Firstly, to attend general meetings and vote, to receive a share of the company's profits, to receive certain documents from the company, to inspect statutory books and constitutional documents, and to any final distribution to the winding of the company. Duties of the shareholders. The main duty of the shareholders, again, is to pass resolution at general meetings by voting in their shareholder capacity. Shareholders can vote in one of the two ways, on a show of hands or through a poll vote, where each vote will be proportionate to the number of shares held by the shareholder. There are two resolutions that can be voted: ordinary resolution and a special resolution. Ordinary is passed by the shareholder if a simple majority of the shareholders present at the meeting vote in favour of the proposal, therefore more than 50% of the votes. Special resolution is sometimes required by the Companies Act in certain circumstances for the change of articles of association or for important sensitive matters. The articles can also require special resolution. For special resolution to be passed, 75% majority must be voted in favour.
Yeah, this is a famous thing, right? With Brexit, whether it should have been simple majority or supermajority.
Yeah. Brexit was a situation that people, I think, in my opinion, because I teach a little bit of EU law, in my opinion, I think people should have been more aware of the decisions they made when opting out of Brexit. And I think people were not aware. They opted out, but it would be in some ways beneficial for us to have stayed in.
Yes, I agree.
but they didn't. And my opinion, when someone talks about it, is I think that people should have been sent a CD out or some form of leaflet or information about the pros and cons.
Yeah, but nobody did the study. I think it's the
No.
politicians just
Yeah, it's the
spewing the lies.
politicians.
Yeah.
It's the country that's run by
Yeah.
the excellent prime ministers we have in place.
Exactly.
Not. 2.3, explain the process of insolvency for business organizations. Even though in theory they could, companies do not tend to continue existent forever. They either outlive their usefulness to become financially unviable before a company ceases to exist or is dissolved, to use the legal term. Its ongoing operations are brought to an end. So assets are sold and the proceeds of the sale are used to pay those to whom owes money. This is called winding up or liquidating the company. Some companies that are wound up or liquidated are able to pay off their debts. That's why they are solvent, yet the law governing winding up or solvent companies is set out in Insolvency Act 1986. Insolvent companies. The explanation for this is that most winding ups involve insolvent companies, and when in the mid-1980s the law governing insolvent companies winding up was moved out of company law legislation into specific insolvency legislation, it made sense to deal with the solvent windings up in the same statute. This avoided the need for duplication of this winding up provisions relevant to solvent and insolvent company in the Companies Act. Note that insolvency is a term relevant to both companies and individuals, but in the UK the term bankruptcy is used only to refer to the insolvency of individuals, not companies. It's legally incorrect to refer to a company going bankrupt. Finally, in the case of winding up, once the assets of the company have been turned into money and any or contributions secured, the liquidator is required to follow statutory order of distribution. So there was a need to have the winding up and the insolvency in one statute under the Insolvency Act, a separate statute, because it worked better for them in regards to the Companies Act having it in there. Insolvency and administration. Insolvency law is highly detailed and specialized area of legal practice, requiring study of specialist texts for a full understanding of its scope and complexity. That said, the two key formal processes forming the core of insolvency law are administration and liquidation. During the administration and liquidation processes, administrators and liquidators have various powers, including the power to bring legal actions and to review and challenge the validity of certain transactions entered in by the company. Why do you think a company goes into liquidation or insolvency? Why do you think they or starts to wind down? Why do you think the reasoning behind that is?
Well, some of it, right? Meaning in our sector, right? Financial services, sometimes it has a defined, length of the firm that it can only last 7 years, and therefore we have to just wind up, right? So that's one thing. Second thing could be is, as you said, bankruptcy. The company is insolvent. There is no money. I know we said you can't use the word insolvent for the company.
Yeah.
The company may have exceeded its, its equity value is lower than the debt it has. So, you're technically insolvent. You have to.
And companies tend to become, like we said, bankrupt again to try to avoid paying creditors as well.
Yeah, that's right.
And sometimes companies are advised to do that.
Sometimes that is used almost like used in US, like Chapter 7, Chapter 11 bankruptcies. They are really protecting the companies to carry on business while haircutting the debtors.
I know some accountants actually advise you to do that.
Yeah. That's as an accountant, I'm telling you that we do, kind of assess it whether it is better to just go through the insolvency.
It's viable, isn't it? It's financially viable for them to do that. Yeah. So securities regulation. The aim of securities law is essentially to provide protection to those who decide to invest their money in securities. The term security covers a complex range of investment products, including products unrelated to companies. Securities regulation is part of what is often finance law. For our purpose, finance law can be viewed as made of three parts: banking law, the regulation of those who conduct the investment business and the markets on which investments are traded, and increasingly the regulation of companies whose securities are offered to the public. Consequently, basically, securities regulation is often relevant to those companies with shares or bonds traded or listed, which are bought and sold on the stock exchange. Global financial crisis of 2008. Reform of UK law is the result of both UK and EU initiatives. most of the changes to the regulation of the banks and realignment of regulatory responsibilities. Realignment has been affected by the Financial Services Act 2012. The Financial Services Authority, FSA, as such, has been abolished and its functions have been split between two regulatory bodies. A new microprudential authority has been established called the Financial Policy Committee, and the two regulators sitting underneath the umbrella are the Prudential Regulation Authority, which is the subsidiary of the Bank of England, and the Financial Conduct Authority. Fortunately, apart from this change of regulator, the framework of securities regulation has remained intact. Arguably, the FSA has simply been renamed and refocused, with some of its functions being removed and given to the Prudential Regulation Authority.
Yeah, it's really banking versus investments. Basically, that's what's happened. Banks are PRA and asset managers, and others are FCA.
Yeah, I think it's changed a lot, hasn't it?
Mm-hmm.
The key securities regulation statute in the UK remains Financial Services and Markets 2000. The 2000 Act established and empowered the main securities regulators to make detailed provisions governing securities. Focusing for a moment on the sources of securities regulation, statute provisions in the FSMA are supplemented by detailed provisions made by the FCA pursuant to powers. This clearly legal regime is supplemented by what is increasingly referred as soft law, important examples which are UK corporate governance and the Stewardship Code. 2M1, advise on the insolvency process for a given situation. Insolvency is legally defined as follows: a company is insolvent, unable to pay its debt if it either does not have enough assets to cover its debt, i.e. value of assets is less than amount of liabilities, or if it's unable to pay its debt as they fall due. An individual is insolvent if he or she is unable to discharge his or her debts as they fall due. There are a number of reasons why a company might become insolvent. Loss of the market, so where the company has not recognised the need to change in a shrinking or change in marketplace because of their margins have been eroded or because their service has been overtaken technically. Management failure to acquire adequate skills, even through training or buying them in. Over-optimism in planning, imprudent accounting, lack of management information. Fraud, loss of long-term finance. Other reasons including excessive overheads, new ventures, expansion or acquisitions. So insolvency case study. Case study 1, use of insolvency system by creditors to initiate bankruptcy liquidation proceedings. The client C is a local supplier of goods in your country. One of the client's customers, a local privately owned limited liability manufacturing company, which is D, has failed to pay a debt due to the client in the local currency equivalent of £10,000 as a result of the cash flow problems. The debt is more than 30 days overdue. There is no dispute regarding the underlying transaction that gave rise to the debt, and the debtor has no valid defence for the non-payment of the debt. The client now asks for the professional advice on any action the client can take under the insolvency of the country to deal with the apparent insolvency of the debtor and the process that will be involved obtaining an effective final order against the debtor. In this, it was the effect that the affairs of the debtor will be therefore administered under the Insolvency Act, whether by the way of bankruptcy, liquidation, or some other form of insolvent process. It does not mean the end of such processes. 2D1, analyse aspects of capital maintenance. The capital maintenance concepts, I think states that a profit should not be recognised unless a business has at least maintained the amount of its net assets during an accounting period. Stated differently, this means that the profit is essentially the increase in net assets during a period. This concept excludes the following cash inflows and outflows that impact net assets. Firstly, increase in assets from sale of stock to shareholders increases cash, decreases assets from the payment of dividends or distribution to shareholders, decreases cash. The capital maintenance concept can be skewed by inflation, since inflationary pressure will be inevitable increase net assets even if the underlying amount of assets has not changed. Thus, it is more accurate to adjust net assets for the effects of inflation in order to, if the capital maintenance has occurred. Capital maintenance idea is concerned with the net change in account balances during an accounting period. It is not concerned with the proper maintenance of the actual physical equipment owned or operated by a business. The share capital of a limited company is regarded as better fund for creditors. The rules on maintenance of capital exist in order to prevent a company reducing its capitals by returning to its members, whether directly or indirectly. And this means that, as a general rule, a limited company can not reduce its share capital. However, an exception to the general rule is the reduction of capital. Under Section 641 of the Companies Act 2006, a company can reduce its capital at any time for any reason. Firstly, to reduce or cancel liabilities. Secondly, to reduce return capital in excess of company's need. And thirdly, to cancel the paid up capital that is no longer represented by the assets. Procedure for public companies. So they pass a special resolution. They apply to the court to confirm the special resolution. If reduction involves one of the first two methods above, the court must require a company to settle a list of creditors entitled to object. The court must not confirm the reduction until it's satisfied that all creditors have either consented to the reduction or had their debts discharged or secured. The company must file documents with the registrar. If the share capital of a company falls within £50,000, it must re-register as a private company. Procedure for private companies. So they pass a special resolution supported by a solvency statement. The solvency statement is a statement by each of the directors that the company will be able to meet its debts within the following year. A solvency statement made without reasonable grounds is an offence punishable by fine or imprisonment, and copies of the resolution, solvency statement and a statement of capital must be filed with the registrar within 15 days. So this is some additional information that you may need to look at as well. Treasury shares, the definition of what a treasury share is. These are created when a public purchases its own shares from distributable profits. The shares do not have to be cancelled. Up to 10% of the shares can be held in treasury, which means they can be reissued without the usual formalities. And general rule, shares which are purchased by a company must be cancelled and the amount of the company's share capital. Do you think it's a good thing to have shares in a company? I'm not saying it's a bad thing, but do you think sometimes it's a good thing to have shares in a company?
Yes, it is. Yeah.
Do you think it's a good? Do you think it's always profitable though?
Not always, but usually it is. Not always,
Yeah.
of course. Yeah.
Yeah, and especially if you're involved a lot in the stock exchange and things like that, you're able to identify the issue around whether the company's doing well or not.
Yeah, exactly.
And I think
And if
at the
it's
moment,
listed, right, winning equities, it's pretty much traded in the market. So, equities right now is thriving in the current
yeah,
market.
it's thriving, but in certain companies with all this stuff about the war and things.
I was about to say, yes, exactly.
Sorry, you were about to say the issue around Palestine and things.
Yes,
A lot of the companies are going down, aren't they?
Yes, right. And remember now the issue is with this ESG criteria, right, in our sector. So we are not allowed to invest money with defense companies, for example.
Okay.
So there is a lot of kind of, exclusion criteria, or there are a lot more criteria that we can now use to invest or not invest. So you're right. I think this is
I think a lot of the companies are going down. Things like, I think Coca-Cola, Starbucks, is it? Costa.
Yes.
Companies have lost a lot of money in the since October the 7th.
Yes. And that is some of it is sentimental value. I mean, I am not talking about politics. I mean, geopolitics takes an important part in it, right? I think some of it is a brand valuation issue, right, in these equities, right? The other one is basically a dent in their turnover. The other one is, reputational risk. Could be some of all that affects their market value. It
does have a spiral effect, doesn't it, though?
Totally.
Yeah. So some of the exemptions under Section 724 of the Companies Act, companies listed on the stock exchange or the alternative investment market can buy, hold and resell their shares. The shares must be qualifying shares, which are shares listed on the London Stock Exchange or traded on the alternative investment market. Under Section 726 of the Companies Act, the shares will not give the company any voting rights in respect of their shares, and any consideration received on the sale of treasury shares is to be treated as profits for distribution. Under Section 729 Companies Act 2006, in the event shares are cancelled, there will be a reduction in capital, but there's no need for special resolution of the members of authorisation by the court. Section 730 Companies Act states that where treasury shares are cancelled, the company must deliver a return to the registrar not later than 28 days after the shares are cancelled. The notice must be accompanied by a statement of a capital, which must state with respect to the company's share capital immediately following the cancellation, the total numbers of shares of the company, the aggregate nominal value of the shares. For each class of shares, it must be prescribed particulars of the rights attached to the shares, the total number of shares of that class, and the aggregated nominal value of the shares. The amount paid up and the amount unpaid on each share and treasury shares can also be created when a company initially issues shares to keep the public, but keeps a proportion in treasury to be sold at a later date. These are the references we've used for today's session. You could go onto them: Law Explores, Entrepreneurship Handbook, Quality Company Formations. These will help you towards when you're doing your assessment, and there's additional reading on the Moodle site as well. Refer to ebooks and journals again on Moodle, and any inquiries you've got in regards to any issues or anything around that is learnerworks@ukvarsity.co.uk, and it just goes on about submission of the assignment, which is submitted after 2 weeks of completing the module. Has anyone got any questions before we finish the session off?
I only have one question, Shazia. So once you complete the assignment, after 2 weeks of completion of the units, how long does it take for you to say you pass, fail, whatever? Well, there's no fail.
I think
pass,
it's dependent on when it gets marked, and they tend to try to get it marked straight away.
Okay.
And once it's marked and it's sent to the actual body that your qualification is from, I don't know the exact time limit, so you're better off emailing them. But I do know that 2 weeks after the completion, it may come to me to do the marking and things.
Right.
And then it would be sent to the external body that's dealing with your qualification.
Right. Okay. Got it.
Okay, so I mean, email them. They will tell you everything more in advance. Learner work at UK Varsity.
Mm-hmm.
And this is normally done after your assignment is normally done after your 4 learning outcomes are complete.
Mm-hmm.
So once you've done all your learning outcomes, which is the 4 that you've got to do, 2 we've done yesterday. We did 1 learning outcome 1. Today learning outcome 2. Next weekend learning outcome 3 and 4, and then the weekend after. The Saturday will be the assignment discussion,
mm-hmm.
and then you can start doing the assignment. And I think a lot of the stuff for the assignment is in the slides.
Got it.
Has anyone got any questions? Any more questions? Hanish, Danny, Najam, Irene?
No questions.
Thank you, everyone. Thank you for your patience, and thank you for attending today's session. I know it's got a bit over. It tends to do in these kind of areas. But thank you for attending, and thank you. I will see you in the next session next week.
Thank you.
Are you going to be taking off next week?
Yes.
Okay.
Why do you want me to take? Do you want me to take you next week or not?
I do want you to. I want you to. Thank you, Sasha.
Thank you, and I will see you next week. Have a nice week, everyone.
Thank you. Bye-bye.
Bye-bye.
Bye, Hanish. Bye, Najam, and bye, Irene. Thank you.
Cheers. Bye-bye.
Bye.